All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Opinion Counsel presiding is now in session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have today 5 cases that are going to be argued, and we're using a lot of technology. Our last case is going to be argued on Zoom, so I'm going to read through the cases, but anyone that's here for our final case, you'll have to catch that on a separate Zoom argument that we will be broadcasting. And we have Judge Zayas is here remotely. You see her on the screen for the other cases. So hopefully that technology works out. This is the first time we've ever used our hybrid technology in this courtroom, so hopefully all of that works out. I'm going to go through the cases, and if the attorneys would please state your names, who you represent, and your readiness to proceed, I would appreciate it. The first case for argument today is State of Ohio versus Christopher Souders, case number C-23-0153.
Who is second appearing on behalf of the appellant, Christopher Souders?
Thank you.
Judy Lapp, State, ready to proceed.
All right, thank you. The second case for argument today is Bank of New York Mellon versus Nicole Mitchell and Michael Griffin. I'm sorry, the case numbers are C-22-0438 and 041.
Nicole Mitchell. Michael Griffin.
Oh, thank you. Ready to proceed.
David Wallace, the Bank of New York.
Okay.
Ready to proceed.
The third case for argument today is case number C-22-0542, Patricia Andwan versus Eichert et al.
Good morning. My name is Patricia Andwan. I am pro se reluctantly, and I'm ready to proceed.
All right, thank you.
Jeff Kenny for the ability, Lakers, Warriors.
All right, thank you. And the fourth case we have set today is case number C-22-0521, and hopefully I'm pronouncing this right, Gauthier versus Gauthier.
Robert Klingler on behalf of the appellee Sue Gauthier, ready to proceed.
Gauthier, okay. And Mr. Grossman is not here?
I don't see you.
Okay. Well, we'll see if he shows up. You are the fourth to argue, and then we'll decide what you want to do from there. All right. And then our last case is State of Ohio versus D. Marcia, case number C-23-0380. As I said, that case will be done by Zoom, so we'll be leaving the bench and getting onto a Zoom call for those attorneys. Okay, so if the attorneys and Souders would step forward, and we will get going. Mr. Sorkin, would you like to reserve some rebuttal time?
3 minutes.
3 minutes, and I'll be using the lights at the podium. When you have a minute left, the yellow light will come on.
If it please the court, we're here on State of Ohio versus Christopher Souders. This case originated back in August of 2021 when Christopher, along with 2 other young men, traveled to Cincinnati to, I believe, an inference could be strongly made that he was to collect a debt. The problem that occurred is that there are 2 sides to this story. The one story that was told is really dependent upon the testimony of a young woman, a mother by the name of Elizabeth Ventry. She testifies that these 2 people were out in her backyard. She went out to get her dogs. One dog came back into the house. The other dog didn't. 2 men approached, apparently making an allegation that they had guns. They went into her house. It claims that they asked about where's a safe, where's your safe in the house. She said there was no safe, and they said something about her son, Charlie. It appears that an inference could be made that Charlie owed some money, and he was there, they were there to collect the money. As the morning went on, there was an allegation that Ms. Ventry tried to get out of the house, fell, she, according to her story, bumped her head and bruised her arm. And then later on in the morning, she indicated that there was money in a savings account at PNC Bank. They then went from the house to the PNC Bank, where she withdrew $10,000, went to an experienced assistant manager who was acting as a teller at that particular bank that morning without any suspicion at all. Mrs. Ventry was with Mr. Souders, and there was some discussion. He had indicated that his grandmother was lending him some money to buy a car because he had just gotten a job. There was no indication of anything that was a problem. There was no indication of distress on the part of Ms. Ventry, and they went on to a couple other, to use the banking machines and withdrew some additional money. There was an allegation of a call to American Express, and some additional sums were withdrawn on the credit cards. As the day went on, after they were all done going to the banks, Mr. Souders and his two other company people left the area and went back to Louisville, where they were from and where they had originated the evening before and the morning of August the 11th. Ms. Ventry then went and conducted normal things that she had calendared. She picked up her father.
Well, and so we understand the factual backdrop here, and there's certainly, we understand kind of your assessment of the evidence, and we understand the kind of countervailing evidence. Where do you start with your argument? Because I think the issue regarding the 404B material is an interesting one, but it also wasn't preserved.
Well, but I do think it meets the plain error thing, and I do agree it was not preserved. There was no objection to it, to the 404B. There were two areas of 404B evidence that came in, or basically maybe three, depending on how you look at it. There was an incident that occurred on August the 6th in Louisville, Kentucky, right, where the police were called and they arrived. It was early morning hours, and they had their webcams, and they took a video and they had a discussion with Mr. Souders. He was out in this parking lot of the apartment building where he lived, and he was asleep, and he had a pistol on his stomach. There's no argument about that. That did occur. The problem with it is that there was no objection that it came in.
So they showed this body camera video.
Pardon?
They showed this video.
They showed the video
of the
in
officer's
addition,
body camera
and
to
they
the
also
jury.
had the testimony of the officer who was the one who videoed it. And
the video, as I saw it, was kind of lengthy because it goes beyond just like seeing him, but it goes on to their investigation and so forth. And do we know how much of that was shown to the jury?
I do not know that, because all I had was the video of the whole thing and what portions were not. But I imagine it was sufficient. It was lengthy because there was a deposition of that officer which was introduced. And that's when the exhibit was later introduced as exhibit number 2. And in that, that video itself, but there's also testimony by the officer when he says that because of the kind of hoodie that Mr. Souders was wearing when he was in the car, he had the 13 on it, and made some comment that that was a symbol of a gang in Louisville, and said the word gang, that's a member of a particular gang. Then, in addition to that, there was some testimony by Detective Rui that went without objection, and that was that when they took a DNA, they took a DNA from a bottle that was in Miss Ventry's house that apparently it was identifiable, and the Delhi police had received word from an Indiana police department that indicated that DNA, the match of that DNA, had been gathered at a crime scene in an earlier year in 2013, and the individual with that DNA was Mr. Souders. There was no objection to that. Now, I believe that, again, there was no objection to that. There was a motion in limine at one time filed in relation to this 404B, the 2013. There was a notice filed earlier by the state that on the 404B regarding the DNA or the 2013 incident. However, again, there was an objection filed to that, but there was apparently no argument with it, and there was never a ruling.
So there was notice of the,
And I made a mistake in the brief.
Okay, just so I understand,
That
though.
is correct.
the 2013 Indiana charges, the state filed a notice of 404B.
Yes.
They did not file a notice of 404B for the body camera in
To the
Louisville.
best of my knowledge, I could not find any notice as to that. But again, there was no objection made. So it's got to fit into it has to fit into plain error. I think clearly these combinations of evidence, because of the shaky nature of Ms. Ventry's testimony, particularly as to, one, the gun, and secondly, as to what really happened that morning, was so much based upon, believability of her, in addition to what one may think of Mr. Souders.
Well, let's go back to the 2013 charge. Like, I think it would be much more prejudicial if they said, like, hey, look, he was charged with this offense and he happened to be acquitted of it, and like laid it all out. But it seems to me, based on what I saw on the record, that there was basically a veiled reference to some earlier thing. So, like, how is that sufficiently prejudicial?
Well, but it links in, it says a crime scene. Common sense tells you if you got a DNA from a crime scene, you're looking at suspects. If you're looking at suspects, you're looking at somebody that was related to a crime. And so whether it's outspoken with it, it's just a natural inference that one would make. When you combine it alone, that would not have been that much of a problem, perhaps. But when you combine it, what happened on the August 11th or the August 6th situation with Louisville, it gets really blown, and it's a very large proportion, of making this guy look like a really bad person and a bad individual, gun-tooting guy, combined with the language of a gang, coming into it and putting that into the case. I think it clearly gets to the match of being prejudicial and a miscarriage of justice.
Now, the state's saying that they introduced the Louisville video to demonstrate identity.
Well, this identity was known. They had him at the bank cameras. They had him at all the bank cash machines. They had his video, and she made a positive ID. And the person that was driving the car, who testified that he never saw a gun, by either one of the two other people, and it positively identified him. So
Did he ever admit that he was there?
No, he did not admit that he was there. There was no statement introduced on his part, although his lawyer in opening statement said there's no argument about identity, and I know opening statement is not, it's something from a lawyer, and in closing statement he repeats again, there's no question that he was there.
So his theory of the case was that he was there and that he was collecting a debt.
That's exactly right.
Okay.
And when you put these other things together, and I also claim that there's no evidence, and the court should have granted, at least a reduction or a direct on Rule 29, at least as to the gun specs, because there was no independent evidence that they had a gun, anybody had a gun that day there other than Ms. Ventry making that comment. In going to the credibility of Ms. Ventry, and all due respect to the police department, the Delhi Police Department, they, at first, when they heard this whole story and everything said, had questions about whether this, in fact, was true or whether this was somebody that was said in closing argument, buyer beware, at the end of buyer's remorse. I just gave these guys to protect my son, Charlie, with something, $12,000. Having talked to friends, we don't know what those conversations were.
She did have, wasn't the evidence that she did have an injury, like she said?
She had an injury, but she
on her
also
head?
said, she says the injury in her testimony, she says the injury came because she tried to escape. She got rid of the things that they used to supposedly put her arms behind her back and so on when she tried to get out of the house. When she goes to the doctor 2 days later and she explains what happened, she said, I tripped when they were forcing me up the step to go into the house, at the beginning. You combine that with the statements about, when the testimony really shows that both dogs didn't come back into the house, The one dog was still outside. At one point, Mr. Souders goes and retrieves the second dog. You also have 2 dogs that are in a house who this woman lived alone with at this time, and there's no reaction, there's no testimony of what the reactions of the dogs would have been if, in fact, she had attempted to get out of the house and fallen on the ground. Where were the dogs? What were they doing? There's no evidence.
Depends what kind of dogs they are.
Well,
because-
one's a big dog and one's a smaller dog is the only indication that I remember in the testimony about the size of the dogs. There's no video of him going to pick up the dogs and so on. So I think when you put it all together that way, I mean, yes, it sounds like a horrible story, but is it just a story and is it buyer's remorse? And we don't know. And the jury didn't, when you add those additional factors that they were given, it really makes Mr. Souders look like a really bad person. Crime scene in 2013, this 2021, sitting there in a car with a gun on his stomach, and the testimony combined about the gang membership. And I'll use the rest of my time in rebuttal. The issue dealing with the DNA is one intellectual one that intrigues me about what happens when DNA is taken, that people are not aware that doesn't, number one, automatically get expunged if there's an expungement. It goes into into the DNA bank, and it's available under CODIS to be available. I do think that individuals who ultimately get acquitted from crimes, that situation, that should automatically be eliminated from CODIS. I don't think it's fair, and I don't think it's right. I couldn't find any really support to my position other than the fact to raise it, and I think there's a substantive due process argument that can be made for that. As to the Reagan argument in count 4, after I filed our initial brief, the decision came from the Ohio Supreme Court. I accept that. And again, on the weight of the evidence, I do think that there was a miscarriage of justice in this case, and I would ask the court to reverse it and remand it for a new trial. Thank you.
Thank you.
Morning.
Just off the top, this issue about saying that it was ineffective assistance of counsel to not file for an expungement of the acquittal. I don't know about Indiana law in detail, but if you have a charge pending, which this man did, you cannot have anything expunged or sealed. So his present trial counsel had no duty to try to seal or expunge the acquittal.
Yeah, I took his argument almost to suggest that it should have been prior counsel who represented him previously rather than current trial counsel, which doesn't, I don't know.
Okay. Point taken.
Yeah.
Let's talk about 404B.
Okay. The video was given in discovery.
Okay.
So no, there was not a notice of intent. It was given to them. All of the videos, the body cams, everything is given in discovery in full.
What was the point of showing the video of the Louisville incident where they take the gun out?
Yes. When he was asleep with.
He was asleep in the car. The officers took the gun apart. I believe one of the officers mentioned something about the gun had recently been fired on the video, but what was the point of showing that to the jury?
Well, first of all, he did not admit identity. At no time did he make any statements. And for an attorney to come up at opening statements and to just say, of course we don't deny any of this because his pictures are there, that does not take away the obligation of the state to prove every element of the crime.
But I think, like, you take that and you couple it with the other video evidence that was available that showed him, like, where was the dispute about his identity?
Because he gave absolutely no statement.
Well, he's
He
got a
admitted
Fifth Amendment right not
absolutely
to
nothing.
testify.
But the state has every right to put on its case. And identity was at issue because he had never admitted it, never gave
But
a
I
statement.
think the problem with that logic, though, is then what you're saying, taken to the logical extension of that, is then every case where someone exercises their Fifth Amendment right not to testify, you would say, well, there's no statement by him that he concedes that he was there, so therefore we get to bring in whatever this evidence is under the auspices of identity.
It was more than not him testifying. He gave no statements to the police. So then what are you having the state do?
He's got a right not to give any statement to the police.
That's absolutely right. But
So
the state
what
had
I'm
the evidence.
asking is, in that circumstance, where a criminal defendant exercises his right not to testify or make a statement, are you saying the state can bring in whatever they want? Because
Obviously not whatever they want, but this was, identity had to be proven by the state to prove this case.
Can you tell us, though, besides this video, were there other ways that the state had to prove identity, or was this the only way? I mean, did you have other evidence of identity in this case?
You had the evidence of Ms. Ventry, all of her testimony, and that she identified him. There were photographs, obviously, of him at the ATM machines. Vincent Quinones testified about the plan to come, the plan to get the money, the plan to go to her house, and he identified Souders in that fashion and talked about where he went and how he followed them. But Ms. Ventry was the one who stated that the gun was held to her head. And you did not have evidence, Vincent Quinones would not say that he had a gun.
So this was used then, are you saying, to show that if he had a gun on a prior occasion, he must have had a gun on this occasion?
That 5 days before the crime was committed, when he had planned this, told Quinones about it, rented a car, that he was found with a gun that matched the same description.
That's like
of what she
propensity, that's propensity inference. That's exactly what the rules are designed to avoid.
I disagree with you on that. This state had to prove its case, and it was permitted to prove its case.
And I'm just trying to understand, how does having a gun 5 days prior to the event make it more likely that he's got a gun on the day?
It corroborated her testimony. And the defense kept arguing, well, there's no evidence of this gun except her testimony. And that her tried to say her testimony wasn't any good. But yet, here, in direct proximity before the crime, and in the terms of showing he was preparing for this crime, the exact same description, it corroborated what she said, the kind of a gun that was shown to her and held on her all morning long.
But then it seems like you're changing the basis for the 404B, because now you're saying it's not having to do with identity, it has to do with the gun.
Oh, it also had to do with identity. He was wearing the same distinctive clothing. And since he had never admitted that he was there, that it was him, this idea of saying suddenly identity isn't at issue, when just because at opening a statement a defendant says, okay, now we're going to say it's not an issue. But he said nothing to the police, and yes, he had the right to say nothing to the police. But the point is, the state prepared Detective Rui, piece by piece, put this case together, and each piece of evidence led to the next and corroborated the next. And the state had sufficient evidence to charge him, and they had an obligation to prove every element of the crime.
Can I ask you, though, because we have the recent case of Hartman that kind of lays out the whole 404B analysis. And in that case, the court says that the defense established during opening statements that consent was their theory of the case, and thus identity was not an issue in this case. So Hartman seems to suggest that the defense can, in opening statements, when they set out their theory of the case, basically stipulate to identity and make it not an issue.
But that was not done in this case at all.
I mean, wasn't that what their opening statement was about? Was their theory of the case was, yes, he was there, but this was a debt collection situation?
That was the very first time that was ever raised. In any of the pretrial hearings, pretrial motions, discovery, That was never raised or stated at all. At all times, it was a complete denial of every aspect of the crime. And the state had to prepare its evidence. It had gone through a very detailed investigation and put the pieces of this crime together, and they had the right to present it.
But you had the officer testify who had the body-worn camera, right?
From Louisville?
Yeah.
Yes, to present that video.
So why couldn't you have just had him say, I apprehended, or I came and I found this guy in Louisville 5 days before the event, and he was wearing the sweatshirt that looks exactly like the sweatshirt that the victim described?
Because we had the right to put the video in to show those things. Everything hinged on Ms. Ventry's credibility, which was constantly being attacked by the defense. And we had this evidence, and we had the right to show that evidence. That was better than simply having a police officer come in without the video. The video put it all together and showed this person and showed it corroborated what her testimony was.
Well, there does have to be a balancing of probative value versus unfair prejudice as well, in deciding whether or not that video
Yes.
should have come in.
Yes, and as there was no objection, it's a plein air standard, to me, there was no prejudice to this.
Yeah, let's talk about that, though, because we are under a plein air standard.
Yes. The officer even had stated, and it's on that video, that he had said no crime occurred. He said, no, you validly have this gun. I'm not sure if he even needed a permit in Kentucky, but it was, there was no accusation that there was any crime committed by him falling asleep holding a gun on his lap. So there's no prejudice. It was simply showing his sweatshirt, his distinctive appearance, that it was him, and by the gun being there, which corroborated her testimony about a description of a large black gun being held to her head for 3 hours in the house. There is.
So if it had been a situation where he was illegally possessing the gun, in your mind, that would be different when we
I'm just
analyze
saying
prejudice.
because they specifically stated this was not illegal, it even goes more towards the fact that there's no prejudice caused by this video. And it was probative and it was relevant to her testimony.
Do you know if the entire video was played to the jury?
You asked that. In my mind, when I looked at what was reviewed, what the video that was kept in evidence, it was not lengthy. It was not lengthy, but no, I cannot tell you right now whether it was 1 minute, 3 minutes, I don't remember that.
And Attorney Lapp, I do have one question, and it goes back to the our standard of review. Is it plain error or is it waived? And I'd like for you to address them individually, the body-worn cam and the 2013 charges.
Those are two separate things you're asking?
Yeah, I'm asking on each one whether, with this record, whether it is waived by the appellant or whether it is reviewed by plain error.
Well, because it was waived, because nothing was raised, the appellate court made...
Right, but is it now considered waived before us? Because it wasn't raised below.
Well, even if
What is our stand?
if it is not raised below, you still can apply a plain error standard. And there was no prejudice, so there's no plain error, is the state's view of this argument. On this idea of the 2013 charges, if you look at the transcript, I have electronic copies of the transcripts and did word searches over and over again. All that was stated, and I know you have the transcripts in your possession, was there was a call saying there's a DNA match from a 2013 crime scene in Indiana. This argument wasn't made, but the DNA could have been from the victim. Defendant could have been the victim in that crime scene. Nothing was ever stated to connect. It said there was DNA at a crime scene, it matched the defendant. That's all that was stated. There was nothing about a murder charge or an acquittal. All of this that was put in the brief was not in evidence at all, and it was never stated to the jury. So
So it was just a passing reference that DNA was collected at a crime scene.
And that this, yes, and that the person that worked at CODIS makes a call that got to Detective Rui that said, here's a match. This is the person we have. And it said Jared Souders. And he then had to further investigate that to be able to tie it to Christopher Souders. But nothing else was said. This, I don't know why the arguments have been made in the brief, because none of those words were stated in the brief, and you're not going to find them. And there was no reference in the transcript to it. And it had to be, to tell the story of how these pieces were put together, it was necessary. On the weight of the evidence, this idea of saying, a jury can look at inconsistencies, and it's the jury's province to decide whether there's credibility to a witness. And that's what was applied to Ms. Ventry's testimony. Clearly, the woman had been in shock at what had happened, and I think that comes through the transcript when you read it. But if this was simply an agreement to pay off a debt, why would you stake out the house the night before? Why would you have to come at 3:30 in the morning and wait for her? And that when she comes out in her nightgown to let her dogs out, she's grabbed, basically kidnapped, pulled in the house, tied down. That's not, it just doesn't match the argument that they made about her credibility.
And were there, I mean, there was evidence confirmed that she did have a head injury, correct?
She had a concussion,
Right.
1-inch hematoma, a deep bruise on the top of her head. Her elbow was all bruised and swollen. None of that matches with an idea that this was just a simple paying off of a debt. There was no evidence in the transcript at trial about anything having to do with her son. Her son, was not, the defense raised a lot about it and gave these theories, but there was nothing to back any of that up. And everything that she said, yes, there were some inconsistencies or in her memory about what she did when exactly after she finally got out of the bottom of the car and felt like she could leave Kroger's. But all of the evidence that was germane and relevant was corroborated by the other testimony. It's just, and it was it's for the jury to decide, and the jury made their decision.
You are at your time.
All right. Thank you.
Thank you. Mr. Sorkin, you have 3 minutes.
Thank you. To answer your question about the injury, the doctor did testify that the CAT scan was the CT scan was taken that showed no injury, no brain injury. And so
she was injured.
She was injured. She had a bruise. Now, whether she had that bruise before or after or whenever, we don't know. Whether it was from a fall-up, going up the steps back into the house, or whether it was, as she described it, was a question. I want to go back to the situation with the car and the testimony, because when you put that together, first of all, there was no crime committed in Louisville on August the 6th. And it was not unlawful for him to have a pistol that was on display.
And that was testified to.
That was testified to. So again, the only value of using that, there was no question about the identity. They had another guy that was going to testify, who did testify, who admitted, and said that we were here, and that we went to that, he went to that house. And so there you have that identity. You have all the photos from the videos that show him, and she made a positive identification on him in the courtroom. The other person also made an identification to him. What other reason would there have been other than to show that 5 days earlier, he's got a gun He lives in Kentucky. It's legal to have the gun. There was no crime committed. And so why show it other than the fact they can say now that, you know, it was to show some pattern, some mode of operation or whatever. Mode of operation to what? The planning to what? It's not unusual for people to have rented cars. In and of itself, that's not a crime. And number two, it's not a crime in Kentucky to have a gun. So why would you show it? You want to show this guy with his sweatshirt, this hoodie, with his 13, you know, and the ultimate, again, tying that to the comment made in the video deposition that was played of the police officer, that that's a symbol of a gang in Louisville.
But didn't they do a search of his place and they found a gun after
Yeah,
the
but that
fact?
was afterwards. He had a gun. He owned. So
Right,
he
but
owns
so
a
there's
gun. It doesn't mean he
evidence.
travels all the time with a gun, and because he had a gun 5 days earlier in a legal situation, that he would have a gun 5 days later.
But there
If
was
it
evidence that he had a gun that came in, and you're not contesting.
a gun. He had a gun that was taken from his house. She didn't identify that gun as the gun he had. She couldn't describe the gun. She said it was a large gun. And then the police identify what kind of gun that they found in the house. It doesn't mean that's the same gun.
I'm just trying to understand how this meets the plain error standard as far as affecting the outcome of the trial.
But you put on the character of this individual, you portrayed him and showed evidence that was not part of this particular case.
And how does it show if the testimony was that he was legally in possession of the gun and he wasn't committing any crime, how does that show that he's a bad person?
But why would you show it? What other reason would you want to show it? Other than to make him look bad, it's early morning hours, he's sleeping in a car, he's a bad person when you tie it now to this number one comment about gang, and number two, about this from a crime scene. So now you've portrayed him, hey, this is really a bad guy, he's got to have a bad motive. And that's exactly what 404 is written to, you know, to prevent. And I think it's a serious miscarriage of justice that he's entitled to a fair trial as to the events that happened on that night. There's no evidence of planning. There was no evidence of that. They go up there earlier. There's evidence if you go back through the transcript of the guys that did the cell phone towers, that apparently they went back to Louisville after they were at the house and then came back again in the morning. So, I mean, there is a dispute about that as to, you know, being there and stayed there all night. So I think when you put it together and you put it in its portrayal of Jared Christopher Souders as a bad person, he's got a gun in his car, he's out in the parking lot late at night, and the Louisville police are called, and then you have comments about 213 about, you know, a DNA bank and from a crime scene, I think it's highly prejudicial and it's plain error. And we have the right to raise it on the appeal. Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your morning. The next case up is Bank of New York, Mellon versus Nicole Mitchell, Michael Griffin. Good morning. Are you both going to be splitting time this morning? You have 15 minutes total, I believe. Yeah, you have 15 minutes total, so are you both wanting to argue?
No, just Nicole.
Just Nicole, okay. Then would you like to reserve some time for rebuttal out of your 15 minutes? Okay, how much time would you like to reserve?
4 minutes.
4? Okay, I'll keep your time. On the podium, you'll see lights. The green light means that you're good on time. The yellow light means you have 1 minute left of your initial time, and the red light means you're finished with your time, okay? So whenever you're ready, if you want to step up.
I have a neurological deficit. I've just had surgery for it, so I have a speech
Okay.
deficit. Okay.
Okay, thank you. Whenever you're ready.
Okay. The Bank of New York was time barred when they filed this case in the trial court erred in its adoption of the magistrate's decision to deny our summary judgment. The trial court abused its discretion by ignoring the appellant's argument and pleading that proved that the appellee was time barred from refiling its case more than a year later after filing a voluntary dismissal on January 3, 2017. Appellee refiled its case on May 29, 2019, when in fact it should have filed its case no later than January 3, 2018.
And Ms. Mitchell, like, these were the arguments that you all raised in the prior appeal, right? The whole issue about the timeliness and all of that, and we disagreed with your arguments there. So what has changed that would allow there to be a different result at this point?
Well, the trial court gave the Bank of New York a summary judgment.
Right.
And when they gave them a summary judgment, they were supposed to prove that there were no genuine issues, and there are several.
Right, but just so you, like, procedurally, that issue was decided way back when, and it came up to us, and we disagreed with that argument. You're here now on the 60B motion, which is saying we need relief from the judgment for some reason, and usually that is because you've discovered new evidence or something like that. And I'm just trying to understand, is there anything new that would suggest a different result here? Does that make sense?
It makes sense, but I just don't know how to answer you except that we asked the court to set aside their judgment.
Right.
And they did not. They gave them a summary judgment, and there was still evidence left to discuss. And we asked for a jury demand when we put in our counterclaim, and we did not get a hearing or anything. And it is like the papers just shuffle, and we don't get heard. And so I don't know if I answer your question.
You did, thank you.
Okay, so do you want me to continue?
Yeah, please.
Oh,
please.
okay. Because the Bank of New York did not present the court with a justiciable cause, the trial court lacked summary jurisdiction to render any decision and judgment on the Bank of New York favor. And so the absence of judicial issue, the court lacks subject matter jurisdiction. And when the court lacks subject matter jurisdiction, any judgment it renders is void ab initio. It's unreasonable for the trial court to deny the appellant the right to even quiet the title, which I'm in possession of, the owner transfer certificate of title. It is the original title with the state seal on it. And it's unreasonable that the trial court would not allow us to even proceed to quiet the title. The Bank of New York have viewed our title, but is relying on the court to ignore the fact that I qualify for quiet title. Just ignore the fact that I have a title and also have a report from the land examiner, and the land examiner identified not only the Bank of New York, but they put in the court some modifications. And these modifications, the people who created the modifications are also identified in the land examiner's report. And it says exactly that from this exam, I determined that the underlying mortgage had never been assigned with the authorization of the mortgagee, and the assignment of mortgage identified should be counsel of record and removed from the certificate of title. And the certificate of title is my title. not the ones that they have created fraudulent documents into the court. You can go and look at the, what is it called, the land examiner records, and you will see where they have put things in the code, error correction, error correction, error correction. All these activities they're doing on my title. I bring with me, every time I come to court, all my original document, everything I got from title company, from closing, the long form, everything. What they present to the court is black and white photocopy, Photoshop, redacted, mark out numbers. And I'm saying, if you say it's me, then show the number that you say belong to me. Because I have the original documents of the numbers that belong to me. And so, I'm sorry, I will move along. The trial court error when it allowed the plaintiff to enforce an inactive mortgage from a original mortgagee that had become civilly dead. The Bank of New York failed to address and refute any facts that MERS was nominee for a civilly dead mortgagee. One cannot be the agent of a non-existent principal. You can't be the agent and the principal at the same time. Otherwise, there's no agency relationship. You have to be one or the other, and they're trying to make them to be both. It is axiomatic that fraud vitiates and makes void everything that it enters into. And this includes a judgment rendered in a proceeding which has basis for fraudulent documentation and fraudulent foundation. It is the trial court acted unreasonable by ignoring the various frauds that Bank of New York has committed. They have been after me since 2013. And in 2013, they mailed to my home a modification. When I would not fill it out, now they produced some modification. They didn't have affidavits, so now they've created these affidavits. That case was dismissed for failure to prosecute. Then they come back in a timely manner, and now they've created more documents. And when I bring forth my original document with seal and stamp on it, the court ignores it as if I'm making it up. And the trial court error when it allowed the plaintiff to avoid a default judgment when they failed to timely answer any of our mission. If I would have failed to do something in a time frame, I would have been headed default. But it appears that the court lets them put stamps on their paper, say, oh, we saw it. Seeing it is not the same as responding according to the rules that say you have to do this in a certain time. If I would have done that in a certain time, they would have said, oh, you're in default, too bad. And so it just appears that they are allowed to do things and just ignore the fact that I have my original documentation. They have black and white, photocopy, redacted, stamped with other things on it, and nobody wants to come to the table to look at each one of our documents to see who is telling the truth. Their story has changed over and over and over again every time they come back. Mine has never. I say the same thing every time that I come to court. If the trial court act unreasonable by ignoring a report from the own Hamilton County official examiner of title, Donald Schenck, who proved that the Bank of New York has engaged in fraudulent recordings concerning my record, but not just my record. If you look, you will see other records where they have falsified documents. They did not even have a license to do business in the state of Ohio. They were not registered with the Secretary of State until our case in 2016, when we brought it to the court's attention that they don't even have right to steal people's homes. They ignored us and let them continue to steal people's homes. This case is bigger than just my little old house. You would think there's gold under my house or something. This case is bigger than that. I have the title to my home. I have a land examiner's report that says it's my title. It also identifies the Bank of New York. It also identifies the people in their modification, who created the modification, as saying, he even wrote a note on here, assignment should not have been recorded. He said it failed. It says, failed, lack proper chain of title. If they're allowed to do this to me, then they will have record. This is a monumental case. This is bigger than me. And because I'm able to fight, because I'm a nurse, I'm trying to redocument my background is policy procedures. So when they send to your home all these stacks of paper to try to intimidate you, no, we take time to read the small print, because what we find is they make photocopies of the same thing 2 and 3 times, trying to intimidate you to make the stack look bigger. And what we have found is, not only have they done this to me, they try to do it to other people. Can you imagine them stealing homes of a widow who put the paperwork up when they send you your title in the mail from the title company? Said, put this in a safe place. So you put your title in a safe place. Then all of a sudden, here come a bank that say, oh no, we own you, we own your home. And here this little lady don't know what to say. I have my title. What do you mean? I have it. It happened to a person who worked in the courthouse. We met her. She had no recourse.
I just want to let you know, if you want to reserve your time for rebuttal,
okay,
you're at your time.
Okay, I'm sorry.
Okay, that's okay. I'll reserve the rest of your time.
May it please the court, my name is David Wallace. I'm here on behalf of Bank of New York Mellon as trustee. The issue in the cases, as you mentioned, Judge Bergeron, is whether the trial court abused its discretion in denying motions to vacate the judgment below, which were filed post-judgment and post-appeal by the appellants. And the answer is no. The motion simply reiterated the arguments that they already made, and there was no abuse of discretion. So the court should simply affirm the trial court's judgments. You know, taking a look at the briefing that they filed, and of course the argument that we just heard, very impassioned. I understand that the appellants are very passionate about this case, but this court has already reviewed those issues very carefully. The trial court reviewed them carefully. There was actually a hearing that was conducted in front of the magistrate. The magistrate issued a decision. The judge affirmed and adopted the magistrate's decision, and then this court heard all these issues last year and ruled against the appellants after reviewing all the materials. The arguments we just heard and that have been raised have already been raised. This court has reviewed them carefully. They have been rejected. Res judicata prevents the repeated repetition of arguments that are already made. Res judicata precludes the filing of Rule 60B motions that raise the same issues that were raised or issues that could have been raised below. And Rule 60B precludes the repeated filing of similar motions. There's really nothing more to say. The issues have been decided against the appellants. This court should affirm the trial court's decisions below. If there are any questions that the court has, I am happy to answer them, but the issues really are very straightforward here.
Thank you.
Please, we request that the court affirm the judgments below.
Thank you.
Thank you. Ms. Mitchell, you have 4 minutes for rebuttal.
A motion for summary judgment shall be granted if the court, upon viewing the inference, be drawn from the underlying facts set forth in the pleading and disposition's answer to interrogatories, written admissions, and affidavits in light most favorable to the party opposing the motion, and that there are no issues of material fact remain to be litigated. There are issues that remain to be litigated. And because the appellants filed motion to set aside or vacate the judgment, and the trial court acted unreasonable in failing to acknowledge our meritorious defense, obligation. The court should remand this back to the trial court with instructions for a jury trial on the merits. We asked for a jury demand when we filed our answer and counterclaim, and have every right to have this case tried before a jury of our peers, and let others decide. I think that is, and regarding the documentations that they have filed into the court, any unregistered claim or interest cannot prevail against a valid registered title. And he said that we had a hearing. We did not have a hearing. We come and we said what we said. They said what they said. And then when we tried to speak up, she told us to be quiet. They just shuffle you along as if you're nothing. And I don't know if it's because you don't have an attorney or what. And at that time, I had regular speech. This was before I had 3 brain surgery. They shuffle. We did not have a hearing. We spoke, he spoke, and then she just ruled, I don't want to hear that, and moved on. And we have said this time and time again, where I said you send it back and let's have a jury trial. We don't have nothing to hide. Our documents have seals on them and signatures. And they are from Hamilton County. Their paperwork is black and white, photocopied, photoshopped, and no one has examined. He said they've looked at it. Nobody with 2 eyes can see have looked at both of our documents together and can honestly say, oh yeah, this is legitimate. This could happen not just to me, it could happen to anybody. And if they are allowed to put on record that they can steal homes of someone who has a title, then that means I have a title to my car. Somebody can come along, they start doing that. They can steal anybody's home. If they start putting this on record like that, that's not fair to the American people. What is the purpose of us having a title to our house and then going and get it examined, and they say, okay, yes, this is true, and then the court said, no, that's unfair. We asked for a jury trial.
Thank you. Well, thank you both for your arguments today. The case is now submitted, and we will issue a timely decision. Thank you. Have a good rest of your morning. The next case is Patricia Andwan versus Eichert. And Ms. Andwan, would you like to reserve some rebuttal time out of your 15 minutes?
Yes, I believe my briefs cover most everything, so I'll take 10 minutes for rebuttal and close.
All right, so you want 5 minutes for your initial argument and then 10 minutes for rebuttal?
Can I part of that argument if it doesn't get included in the second?
Sure, I'll reserve whatever you don't use, but, okay. So I'll let you know when you are at 4 minutes, the yellow light will come on, and then the red light will come on when you're at your 5 minutes. So, sure.
So these are the lights here?
Yes.
Okay. Good morning, Your Honors. It's a privilege to be here. It's like I've been grasping at straws for 5 years, and it's a blessing to be able to address you this morning. My name is Patricia Andwan. I'm a 77-year-old plaintiff appellate, and I have PTSD. The Hamilton County courts have previously already acknowledged my indigency, so I am actually today appearing not only reluctantly pro se, but also as indigent. Today we meet to kind of redress the issues and the harm that has been done by the actions in the lower court by Judge Jennifer Branch. The entire case, the docket, how everything was handled just got totally off the rails from what should have happened. I have a copy here of the application that I made for pro se, pro bono representation, and I just found this on your website last week, but I did want to let you know that I did file this. I'm sure it's too late in the game to make a difference, but I did want to acknowledge that, okay?
Okay.
The other thing that I wanted to see if you wanted to accept, or I could give it, maybe file it later, would be clear copies of the auditor's pages, because when I was examining my files, it looks like the ones that were sent originally were kind of black, difficult to read.
Are those in the record?
Well, they're in the record, but the problem was when I looked at my copies, they looked like they were not clear from the scanner or whatever, that were kind of difficult to read, and this would be just be clear copies.
So well, I think what we rely on what's in the record,
Okay.
so
if it's hard to read, then you would just go to the website and figure it out.
We'll figure it out.
We'll figure it out.
Okay, I figured you guys did the system. So I've already requested my times. But I believe that this particular case is going to set a precedent. And I will say I admire the woman who was here earlier with the passion that she showed as pro se. It takes a lot of guts to come this far, and it's a very painful experience. But I understand your role here is to establish precedent, and you hold the legal authority over those lower courts, so I admire that. I am asking under no circumstances if this would be considered for a remand, that it would go anywhere near Judge Jennifer Branch's court, because I think the evidence in the briefs indicate that that's not a good idea. I know the court has the power to overturn the original findings and make recommendations for the future. What opened the door for me to be here today, because this original trial happened in 2021 in May, as things rambled on, it turned out that I was asking for indigent assistance for legal help, and twice Judge Jennifer Branch turned it down, which in a way was kind of a godsend, because then it opened the door for me to come before you this morning. She had threatened me with incarceration for something that she claimed she had substance for as an indirect contempt of court. And that was terrifying to me, because she quoted up to a 90-day jail sentence and $1,000 in fines after she had already taken my property from me. So it was a terrifying, terrifying, terrifying experience to have somebody sit there and say, you're not in criminal court, but all of a sudden I'm going to slap you in jail for 90 days because I think you did something that I didn't like, got under my skin.
Didn't she, so she was threatening you with contempt because she ordered that you permit your neighbors to install a gate in the fence,
right, and they were already installed long before she issued her order giving them the right to do it. I had installed them according to her timely, the date when she finally gave me a time to install by. They were installed like a week prior to that. And at a later hearing, after this nightmare of, she emailed out an order giving them, the appellees, permission to either put in gates or tear down all my fencing. This is fencing that has been there for 40 plus years. And so anyhow, at the following hearing, because she emailed this order, unfortunately she emailed it to an email address for me that hadn't been in use for like 8 months. And her court had been exchanging the clerk and I emails to the correct address. So number one, how legitimate is that to even process something that way? The other thing is, all of us know that if you send an email to the wrong address, boom, immediately you get a response that says it's undeliverable. So I have no idea how all this happened, other than the fact that, as one of those pictures shows in my brief, Mr. Eichert shows up on my front porch holding a chainsaw, stating that he was going to cut down my fencing and proceed with this order of the court, which I had not received. So with the police and everything that was involved, the next thing you know, we had to have some more hearings. But getting back to my right to have an attorney, she violated Ohio Revised Code Section 120.06A1, where the state says there's a duty to provide legal representation to indigent adults and juveniles that is due to any possible adjudication that includes the potential loss of liberty. And she made it very clear. She even described how she was going to have the sheriff escort me out under my arms to leave the courthouse. So it was a terrifying threat.
So your argument is that once you were threatened with contempt, she should have appointed an attorney?
Exactly, because she was threatening with incarceration. And I realized that some of your local laws kind of leave that out, but the state law is very clear on it. It says, due to any possible adjudication that includes the potential loss of liberty. And I petitioned her twice for that, and she denied it, which opened the door for us to be here today. Okay.
And I just wanted to let you know that you are way past your initial 5. If you can keep going if you'd like to go.
Okay, but I'd still get my other time.
You have a total of 15, and I'll keep the balance.
So anyhow, the briefs that I've provided you actually gave you a 19-page spreadsheet. I critically examined every word of those transcripts to identify the various types of errors that this court had made. Abuse of discretion.
I think the issue in this case is somewhat similar to the issue in the last case, because you didn't appeal the initial judgment by the trial court. And so the trial court made its decision, and then you had the right to appeal, which you didn't.
Right.
And then we're here now on a 60B motion, which is a motion after judgment that says, I want relief from judgment. And you're not allowed to just relitigate everything in the prior case. You typically have to show some sort of new evidence or something new that would change the outcome, because we can't just say, oh, you didn't like the prior result, okay, we can unwind that.
I totally understand that. I understand that your powers here rely on whether or not there had been a fair trial.
Right.
This document of 19 pages is clear and convincing, with a preponderance of evidence, that there was no way, shape, or form that I was given a fair trial. She made rulings. She lied in the judgment entries that she made are littered with lies that are not even supported in the transcript. So we've got 13 pages of a variety of errors, abuse of discretion.
But all of those errors that you believe occurred, all those occurred during the trial, right?
Exactly. But it's based on those that everything rolled forward, continuing to harm me, my property, my health, you name it. It's been like a disease. It's been like a mold that's just creeping along.
Are you trying to challenge the contempt at this point? Because she never
that opened the door.
She never imposed any penalty or sanction for that, right? She kept continuing it, saying, "Hey, if the gates get installed per my order, you'll purge the contempt and you won't have to serve your time."
She kept rescheduling that. She rescheduled it 2 or 3 times.
Right, and it's never been
And the
adjudicated.
reality is, I'm living under the threat And she made it clear that she was quote-unquote sentencing me because she described even how she was going to have the sheriff take me out by my arms and whatever.
But that was only if you didn't comply with her order.
No, this was after the fact. It was after the fact that I had already complied with her order.
Okay, so the gates have been installed
I
installed
gates back in March.
Pursuant to her order.
Pursuant to her order. She wanted two 5-foot gates. They were installed. Photographs were given to the judge, the whole 9 yards. They didn't like the fact that there were split rails to be moved. So fine and dandy, I had a contractor come back and change it to a chain lock. So those things were there. After she okays their ability to tear down all my fences or install gates, there's a hearing at which their attorney actually agrees in the transcript that what I had provided would suffice. It was satisfactory, so to speak. Mm-hmm. But nevertheless, she continued on this rage of wanting to incarcerate me. She was upset because I had reported her for HIPAA violations. I had talked to the administrator of the courts because she denied me having my support dog with me.
You're at 12 minutes if you want to reserve some rebuttal time.
Will do.
Okay.
Thank you.
Mr. Kenny.
Good morning. May it please the court. My name is Jeff Kenny. I represent David and Deborah Eichert in this case, and I've represented him from day one. Procedurally, this case was filed in the fall of 2018. We had a 2 full-day bench trial with Judge Branch. In May of 2018, I believe it was the 16th and 17th of May, she rendered her decision on the 26th of May of 2021, and there was no appeal taken. So as far as I'm concerned, we're here on the 60B motion that the court denied. And the reasoning wasn't filed within a reasonable time. Now, certainly if it was mistake or excusable neglect, which seems to be what the motion contended, it was clearly without.
It was beyond a year, right?
Beyond 1 year. Now, was it reasonable under the catch-all 5? The issue I think here for this court is, was there an abuse of discretion? And we don't believe there was. Ms. Anduan got a very fair trial. Like I said, it was a 2-day bench trial. She presented all of her witnesses. She presented a lot of evidence. We presented witnesses, and she got a fair trial. And if she didn't like the trial, she should have appealed the trial. She did not. And there was a flurry of activity that went on in this case after the trial, after the decision. So it isn't like we weren't going to court a lot. We did go to court a lot. A lot of motions were filed. A lot of things were going on. She had plenty of time to file this motion, file an appeal. She didn't do it.
And there were no appeals of the subsequent things that were going on after the trial?
This is the only appeal.
Okay.
That's right. And to your point, Your Honor, she was told to put the gates in. She was told that she was going to be found in contempt, but nothing happened with that. The gates were ultimately installed. There's been some other issues, but I'm not going to bore the court with that. Bottom line is, there's no evidence in this particular case, in my opinion, that there's been an abuse of discretion. It was a very fair trial. It was a case where she had plenty of time to file these matters within a reasonable time, and she just didn't do it. Thank you.
Thank you.
Thank you.
I do have one question. Thank you. How would you address her argument with regard to right to counsel?
Well, she makes the argument that she should be entitled to receive counsel because she's indigent. And I don't want to get into whether she's indigent or not, but let's assume for purposes of your question, Your Honor, that she is indigent. I don't know of any law in this state where a civil party would be entitled to counsel. And every time I think about that issue, I wonder who's going to pay for it. because it would be incredibly costly to the county and to the state. So I don't think she's entitled to it in a civil matter. If she was threatened with jail time and it was going to be imposed, I could see her point. I really could. If she was threatened with jail time, maybe she should have a counsel there to.
Well, that's what her argument was this morning. Her argument this morning was that the moment that she was threatened with incarceration, that her right to counsel at that point had been initiated.
Correct. And I think that would go to the contempt issue, whether or not she could purge the contempt or would be found ultimately in contempt and have to do a sentence of whatever, a fine, jail term. I don't think that the contempt issue has even been appealed because it hasn't gone anywhere in the trial court level. So I don't think we've reached the point where her argument that she's made this morning has merit that should be considered by this court.
And are you aware of if a trial judge threatens someone with contempt, does that automatically trigger a right to counsel, or does it have to be actually at the imposition of contempt?
I've never seen it where it's been threatened and there's been a right to counsel. I've never seen when there's been imposition and there's a right to counsel. I know I've seen a lot of contempt cases come through the domestic court. That seems to be the location where it's more frequent. So I've never seen it in that realm either. But I understand her point.
Okay.
Thank you.
Thank you. Ms. Sandwin, you have 3 minutes for rebuttal.
Thank you again. I do appreciate your comments. Let's get back to what opened the door here. What opened the door is the fact that not once, not twice, but several times, Judge Jennifer Branch threatened me to have me confined in the juvenile or in the Justice Center.
But so I think, getting back to my question to Mr. Kinney, but she never imposed that.
No.
And so if you have a right to counsel because you are charged with an offense, she doesn't impose contempt on you, then essentially what is your harm at this point, given that she didn't assign counsel, if she didn't actually impose contempt on you?
The harm is that it is terrifying to be threatened like that. The other thing is, the instant she said, this is a crime, even though it's in a civil court, contempt of court, there was no basis for it, and it said, at this hearing, I should have my attorney appear with me. Well, how am I going to do that when I'm indigent, and the law says, the state law says, it's clear that if due to any possible adjudication,
But that's limited to criminal matters. So
no, it says any possible adjudication. If you read that particular section, ORC section 120.06A1, it gives the right to juveniles, and it's talking about indigents, but it also says any possible adjudication that includes potential loss of witness. It was potential, it was possible, as soon as it came out of her mouth. Why wasn't she instructed, or why wasn't I allowed to, at that point, get an attorney? I filed 2 different requests to her to get an attorney. They were both denied. This opened the door wide open to be here. And also, because in an appeal, it is, what I understand your obligation or your purview is to look at what happened, not just one little bitty piece of it. Because right now, we're looking at one little bitty piece. This 19 pages of errors shows that there was no way in heck anyone could claim that I had a fair trial. In other words, my property was civilly forfeited to give these people permission to drive a tractor and a trailer at will through my property.
Right, but I think it goes back to the problem of if you believe that, then there should have been an appeal of that decision.
I understand that. I did speak to an attorney that I could afford a consultation with. I was told that a 60B was good for a year. Number one, I didn't have the funds to go to the expense to install the new fencing and gates and whatever. It was already a difficult situation for me. I didn't have the funds to do that. The court did not give a date that she wanted it done by. It wasn't until they complained for noncompliance that she pulled a date out of the air. I complied with it, sent photos to her, the whole 9 yards, and she turns around and issues this thing that they're allowed to do whatever. In fact, in court, she actually said, let them do whatever they want. Whatever they want. In terms of tearing down all of the fencing around my property that has been there for 40, 50 years, all of a sudden, these dudes are supposed to be able to waltz in there anytime, 24/7, plus she assigned it to the tenants and to people that didn't even join my property.
Ms. Anwar, you are at your time, so.
Okay. Could I add just one?
Wrap up quickly.
Okay, yeah, I do have a little wrap up here.
Okay.
I had requested the court that we have a reversal of both of those cases, which I know you have the power to do. I also asked for the appointment of an attorney, which I know that you can pave the way for that. I have some administrative changes I'd like to recommend to the court, which I'll just file those as a separate thing as recommendations. And I would like to have the appellees charged with all of the damages and all the expenses they have put me through. I've had to borrow money just to keep up with this. I want all of Judge Branch's rulings to be dismissed because they're not worth the paper they're printed on. And even her rulings are so laced with lies, if you try to tie that into the testimony, you won't be able to do so. Thank you.
Thank you.
And I do appreciate your time.
Thank you. Thank you both for your arguments today. The case is now submitted, and we will issue a timely decision. Have a good rest of your morning. Final case is Gauthier versus Gauthier. Mr. Grossman, would you like to reserve some rebuttal time?
Yes, I would like to take half my time for the affirmative case and half my time.
So 7.5? Okay, you're making it hard on me.
I'm not trying to be very particular with you.
You are. I will try my best, and I'll keep your time, and you'll have the lights in front of you.
Thank you.
Yellow light means you have 1 minute left.
All right, may it please the court. The briefs, I think, adequately address all the issues, but I want to remind the court about the basic fundamental claims that are subject to attorney's fees in this case. And those are claims related to an addendum to a full-text separation agreement in a party's divorce, and they only involve 2 matters, and they were very minor. So you have $93,000 worth of attorney's fees, first on a claim involving $150,000 alimony payment. The parties had an agreement that of more than $700,000 paid under paragraph 1 of this addendum agreement would be $150,000 in alimony, and that Sue Gauthier was required to report that on her 2010 tax returns and to pay the taxes on it. She filed her tax returns on time for April 15th of 2011, but she didn't report this income. Forrest was allowed to take a deduction. He had to pay the taxes on full amount, but he was allowed to take a deduction for what was alimony, which he did. And in his tax return, he has to report who he paid it to. Because Sue didn't report the income, the IRS then issued an audit letter in April of 2013 auditing this claim. I immediately contacted Mr. Klingler and told him that she hadn't made the payment and to make the payment and to solve this question, which they didn't do, and that resulted in the lawsuit, which involved multiple issues, but one was that she had not reported this $150,000 on her 2010 tax return. Now, prior to this, they had sued on addendum claims in Warren County Court on a different set of claims, because there were a number of different claims in the addendum, but they sued on a particular one dealing with money that was escrowed to account for a potential future tax liability on their joint tax returns. And we moved to dismiss that claim in Warren County. That motion to dismiss of a prior filed case on the addendum claims was not ruled on for over a year, which resulted in the
next case. Mr. Grossman, I'd like to focus you on the issue that's before us. Like, the backdrop is, like, we understand the basic backdrop, but what we're trying to figure out is, was the attorney fee award appropriate, and if not, what's the issue?
Well, and that's why I'm saying that the backdrop is important, because the issues were so minor. You couldn't possibly spend that money on this, because, for example, on the $150,000, well, we immediately said, look, you didn't file the return, you didn't report the income, and in the complaint we said that, and she denies this for lack of knowledge. Now, she knows what she did and didn't do, but she denied it for lack of knowledge. And then we had to move, and the IRS got back to us and said, oh, okay, it's fine and good that you claim that she was actually paid the $150,000, and you paid it to the attorney. But you've got to prove that it went to her. And so then we asked them for that information. They obfuscated on this. And we had to make a motion to compel, which we won in front of Judge Stitch. And then we were able to give the IRS by August of 2013 the fact that she had received the $150,000, and she amended the return in September of 2013, and the issue was over. So we prevailed by making her change her position on this, where she accurately then filed an amended return, paid the taxes on it. Now, the reason why we weren't the prevailing party is because we prevailed before any judgment had to be issued.
Okay, wait, so that's not on appeal, right? That's been decided.
No, but the question of having attorney's fees of almost $50,000 on an issue that we basically won because they changed their position. And remember, at this point, the only thing we were then alleging was that we would be entitled to the cost of the accountant who had defended that audit, which was only a few $1,000s. That's it.
I mean, it's your argument. You can do with it what you want. But,
okay.
But
so
none
now here's
of the
my
issues
point.
that are on appeal have been discussed yet. And
okay, so
that's what we're interested in.
Okay, so here's my point. My point is, you're arguing about a few $1,000s of an accounting fee, which they're charging $50,000 for, approximately, to litigate an issue that was a non-issue. The same thing with the other issue at Denham was a non-issue. It was only, we didn't dispute.
Are you saying they spent too many hours
Yes,
on this
way
issue?
too much. And in fact, their time that they're recorded is all wrong. And we've submitted, when we got finally, remember, we went up on the first appeal. There's 3 different appeals on this. Right. We won the first one because it wasn't frivolous, where they awarded all the time. And the only reason why Mr. Klingler was recording the time he was commingling everything was because he considered the whole thing to be frivolous. Then we came back on another one, and this is the first hearing before Judge Lubers. And that one, we weren't permitted to cross-examine Mr. Klingler. And you reversed and gave us the right to cross-examine him. Then, because I submit to you that I believe that Judge Lubers thought she was right. Most judges think they're correct.
Comes with the territory.
Exactly. And I don't dispute that. But when it came back on the second hearing, the judge only gave us 1 hour. And that hour, we used the hour, of course, but we were in the middle of highly relevant cross-examination showing that specific entries were not addendum related.
And so let me ask you this: did you make any sort of proffer about what
Yes.
you would have been able to, and what was the proffer?
Well, and I did that during the hearing because I said there was lots of it. And then after the hearing, I submitted multiple briefs that set forth that documentation and set forth the specific things. And we also had an affidavit of bias and prejudice where we set forth in detail the false charges, additional false charges. And we filed a motion to dismiss where we set it forth as well. But
Okay, so hold on a second, because
Yes.
I think you talk about some, like, hundreds of improper billing entries or something.
Yes,
in the
and we
appeal.
set those forth.
You had those in a post-hearing
Yes,
brief where
yes.
did you go line by line on
Yes, we
those?
did. For
Okay.
much of it, we did. But
All
of
right.
course, we went through it in detail with the charges. But remember, we weren't permitted to do this. We said we had lots more questions, and the court cut me off. And I then, of course, wanted to mention what they were, and immediately, as quickly as we could after that, we filed a brief showing a lot of these errors and submitting that to them.
Did
We
you
also
give
filed-
Did you give Mr. Cleaner the billing records while you were examining him?
Yes, we had the billing records because he had them. They were his records.
Well, I know they're his records, but did he have them up on the stand?
They were an affidavit that he filed with his
My
records.
question is, did he have them on the stand?
I believe that he did, yes, because he brought his records in. He brought all of his files in, and he had them with him. He could have taken them to the stand or not had them to the stand, but we were cross-examining him on specific records that were
Well,
his.
but that's my question. How can you cross-examine him on specific entries if he doesn't have those in front of him?
Yeah, well, I believe that he did. But
You're at 7.5 if you want to reserve the other
I would
half.
like to reserve it. Do you have any more questions you want to ask for me first? Okay, thank you.
Okay, thank you.
Morning, thank you, Your Honors. May it please the Court, Counsel. I begin by asking Counsel to restrict his next 7.5 minutes to actual rebuttal, because I have a sense I might be sandbagged here, but that's just my request and my note to the Court. I guess I'll begin on the latest point. I did not have my time records in front of me. I didn't even have my time records in the courtroom, to the extent that that matters. And I don't want to repeat what I've said in the brief, but since it's been touched on, I'll just say Mr. Grossman appeared to be totally unprepared for his cross-examination, and in my view, unserious about making substantive challenges to the records.
He mentioned a post-hearing brief where he sets forth these billing entries that he thought were unreasonable. Did you see a post-hearing brief where he did?
I'm not aware of that. My recollection is that Judge Lubers denied his request at the end of the hearing to file additional documents. And I'm not aware of those being in the record, but I confess I haven't really searched the post-hearing record carefully to see what might be in there. It is clear that Judge Lubers wanted this matter to be resolved. It's litigation that's gone on for 10 years or so. It's been up to this court, of course, several times. The hearing had been postponed 2 times after this court's initial remand for my cross-examination.
And we can certainly appreciate how a judge would want a case to be resolved, but I guess his point on the hour is, we remanded to allow the opportunity for cross-examination, and Judge Lubers limited that to an hour.
Yes.
Now, I don't know what the appropriate length should have been from their perspective, but is an hour too confined for a $100,000 in fee issue?
I don't think so, Judge. And the reason is counsel had 2.5 years since the last fee application to examine the records, to file briefs or memos in opposition, to hire his own expert witness to challenge those records. He had the testimony of my expert, Lynn Punzak, which he could have filed something to challenge. Which
And did they hire an expert or no?
No expert at all. Which brings me back to my suspicion that it's not a serious substantive challenge to the fee petition. It's another effort to delay for many reasons, one of which is there's just been new litigation initiated by counsel in Warren County between these 2 people. So there's been a game for a long time going on of a delay.
Can I ask, though, if he's complaining that there were 200 billing entries that he thinks were improperly billed. How else would he be able to demonstrate that unless he's allowed to cross-examine you about these entries?
Well, he was allowed, Judge, and there's 111 pages, I believe, of transcript of my cross-examination. If you look at those, and I tried to summarize this a little bit in my brief, he used most of his time trying to get me to admit that the case was simple and wasn't worth my regular billing rate that 2 experts had already said was fair. He used a lot of time talking about that, and the judge tried to guide him more than once to get back to something that was more relevant. Then he spent substantial time going over the complaint that had been filed 10 years ago and counting up or asking me questions about how many claims were there. And then he spent substantial time going over the answer, as he started to do just this morning, that somehow some part of the answer had been improper and false. And an answer that had been filed 10 years ago, he spent substantial time during his hour, which he had been forewarned ahead of time, he had an hour. He spent substantial time on that. Then he got to a couple of entries of time records, and he didn't have any exhibits to show me. He had 2 exhibits, I believe, in the whole hearing, the complaint and the answer. No time records, no nothing.
So he didn't, when he was going through asking you about the specific time records, he didn't have anything to put
No,
in your name?
absolutely nothing. I told him, I said, Tom, I can't answer this question without something in front of me. But he didn't have anything in front of him. And so he did not have any evidence that any time records were false. He had innuendo and he raised questions, but he had nothing. He had nothing. At the end of the day, he had no dollar figure. You know, Mr. Klingler billed $10,000 in excess. Nothing. Just, you know, well, Judge, I need more time. There's 269 entries. I need to go over them. Well, no. There's, in my view, no right of counsel in a fee petition hearing to go over every single time entry for the first time without exhibits, without a calendar. Sometimes he said, well, this must have been another case because this date doesn't match. No calendar, no court docket, no exhibits at all. So I think that I know that Judge Lubers gave him some additional time. I think he had about 75 minutes in total. But I really believe, and I think the record shows this, that she correctly surmised that this wasn't going anywhere. He was wasting time. And the court does not have an obligation to sit there for an entire afternoon and the entire next afternoon while counsel examines an attorney over time records with no exhibit, no substantiating evidence at all.
Let me ask you this, though, and correct me if I'm wrong, but the case law does seem to indicate that the court does have to state the basis for the fee determination.
Yes.
Here we have an order simply awarding the fees. So do we have an issue, or does appellant have an issue there where the court failed to state the rationale for its decision? Is that a problem, and do we need to send it back on that basis?
No, I do not believe so, Judge. And
okay, tell me why.
Here's the reason. It's very clear from the record where Judge Lubers came up with her number. It's very clear, even though she didn't write it out in a separate entry.
But isn't she supposed to at least explain in some capacity where she came up with that number?
I don't think that's necessary in a case where it's obvious from the record. The fee, a petition has a number. Lynn Punzak came up with a number. It's the same number that the judge awarded in fees. So it's clear. It's clear how she came up with her number, and to send it back to have her say whatever for all of the reasons set forth in affidavit of counsel and And the expert's opinion, I find, I mean, that would be, it seems to me, make work and form over substance. There's no question in this case how she came up with her decision, and the cases cited by counsel, as we indicated in our brief, are totally different, where a court, for some reason, cut off the time at a certain date, for example, and didn't award any time after a certain date, and the Court of Appeals said, well, you got to tell us why. We don't have anything like this in this case. This court can find out why and the basis by simply looking at the fee petition itself that her judgment is based on, and the affidavit, the testimony of Lynn Punzak, all of which is in the record. So I don't think that's.
So you're saying that in a situation where there's a really detailed record like this, the judge does not have to explain any reasoning for awarding the fee in the order? I just assume.
In fairness, I suppose the better practice, I would say, would be for the judge to have said something about it. In this case, I think it's clear.
Well, I think correct me if I'm wrong, like there's a distinction between if you're asking for $100,000 and that's what your expert says is appropriate, that's what your billing records show, and she awards $50,000 or $75,000, then we don't know
exactly
how she got there. But if she awards $100,000, you're saying like it's essentially you can figure it out.
I'm saying that, and it's even more specific than $100,000 because it's whatever with some sense. Right. So it's very clear from the record what the judge was basing her opinion on, and it was the time records and the testimony of our experts. She found it all to be reasonable. And I want to, of course, remind the court that a fee petition is not supposed to result in a second major litigation. And here we are, up here for the third time. This has become a second major litigation. It's also very clear that the standard is abuse of discretion. And it's also clear from the United States Supreme Court that a trial court should accord substantial deference to the decision of the trial court in a fee petition. So there's simply no basis in the record, in my view, upon which this court can decide, well, she abused her discretion because of what? There's nothing there. So I urge the court to affirm the judge's decision, to move on with this case, to put it past us so we can use our time and the court's time for other things. Substantial justice was done by the judge, awarding the fees she did. Rough justice, as the term in one of the cases is used. We don't become green eye shade accountants. We get a general sense of what the case is, what's fair, and the trial judge applies his or her discretion and makes a decision, issues an award, and that's supposed to be the end of an attorney fee position, and that should be the end here. Thank you.
Thank you. You have 7.5 minutes.
Well, this wasn't a case where the judge just simply awarded all the fees. This is a case where they used an inappropriate quantitative analysis, where the court simply adopted Mr. Klingler's position that, okay, there are 3 issues, there were more than 5 issues. There weren't 3. And then you're going to get 2/3, and you're assuming quantitatively that the time was exactly based upon 3 different types of claims when there were 5, and that all of the time was equal. This is exactly a quantitative analysis that's illegal under this court's law.
I'm confused. What do you mean by quantitative analysis?
Because here's how it is. The court did not do the normal lodestar analysis and didn't decide that the actual time, and this is why I mentioned up front about what they was really spending time on, didn't determine how much time was really spent on addendum law claims, which is the only recoverable claim. Instead, you took all of the time that was recorded, including a whole lot of stuff that's not recoverable, like claims against Mr. Klingler, like the personal property claims, which were the vast majority of the time was on the personal property claims and the stealing of Mr. Gautier's property. That was not what the court did. That is not what Mr. Klingler asked the court to do. Mr. Klingler said, I've commingled all this time. I've block billed everything. Then I tried to separate things out. And all I'm going to ask you to do is take all my time and say that there are 3 claims, which there were more, and give me 2/3 of it.
Wait, you're talking about block billing. I mean, how is he block billing?
He block billed all the time originally. Then he tried to unblock
What do you mean by
bill it.
block billing?
He recorded lots of different items of work in the same time. So he said 5 hours, and for this 5 hours of time, I did this thing, A, B, C, D,
So
and E.
different
That's block
things,
billing.
but
Different
I thought
things.
you were
That's block
saying
billing.
if he was working on like a summary judgment motion and there's 3 different claims, I mean, how, like, that wouldn't be block billing, right?
Well, no, that
Because
would
he's just
necessarily be-
working on a summary judgment
Yeah, but in
motion.
this case, the original time was block billed with lots of different matters.
But where in the record will we find the block billing? Because I didn't see.
It's in the original affidavits. So all the record, and you see, this is the thing, all of his time records were put into the record and filed in affidavits. It was all there. They were all part of the case. And so I was examining him based upon documents that were submitted in court and that are part of the record of this case. And they changed over time because he tried to unblock bill them later and made a summary and, made some sort of a speculation as to how to unblock bill them because the Supreme Court of Ohio ultimately ruled that you cannot award. It said it would never award any fees any longer that were block billed, which is how he did all of the original time. So he's having to, in the quantitative analysis, which this court has said you may not do this quantitative analysis, and he doesn't respond to this adequately, but that's exactly what they did. They took 2/3 of the time, and part of my cross-examination was showing that that's not what was
But can
going on.
I ask you, if he was working, for example, on a motion for summary judgment, and there's 3 claims, and he can only bill for 2/3 of that, right?
No,
Like,
he can't bill. He can only bill for the amount of time for the addendum claims. That's what he didn't set
But if
forth.
everything's kind of intertwined, I mean, how is he supposed to separate that out
He
if
can
he's working
separate
on
it.
one thing?
Yeah, because he knows they can only collect on a prevailing party claim on the addendum claims.
But doesn't the case law provide that if everything's kind of intrinsically entwined, then you don't have to separate it out?
No, it's not, and it's not intrinsically intertwined. They're very different claims, and there weren't 3 claims. He has to establish.
But the obligation, if you're saying, what I take you to be saying is that he was seeking recovery for fees that were incurred that were not reimbursable. And I feel like that's the obligation on you as the party challenging the fee to show the court, look, here's the time entries where he's charging amounts that are not recoverable for this claim. So like which document is that done in?
I do that, and I did that.
Where do we find that in the record?
So you'll see that in documents I filed after this
Specifically,
hearing.
which document? What filing?
I don't have them right now, but I've cited them in my brief. And they're in the brief.
So it's a brief, a post-hearing brief that you filed
And I
that's
did
going to
that.
lay everything out.
I did that.
Okay.
I gave lots of examples of that. And in addition to that, for example, I questioned him on a motion for continuance. The motion for continuance was in Warren County. That motion it was a motion for continuance of trial. The trial was in Warren County. This matter was on appeal. There was no continuance of a trial. He billed for that. I pointed that out to him. He said he didn't know about it. I filed a 60B motion in this case, in the appeal, the first appeal. I filed a 60B motion that relates to the fact that Sue Gauthier was found with the property in her home. I filed a 60B motion. He charges for the 60B motion. The res judicata argument was all related to the personal property claims. I point out that he's billing for these. These are in his entries that mention 60B.
But you're not showing him the entries. Like, I can't remember what I did last week without like a document that would show that. And you can't realistically question counsel about specific things they did or didn't do without giving them the document that says, here's what I did.
And if that didn't occur, it didn't occur because I wasn't given the time for that to occur.
You weren't given the time to hand a document to
No,
the
I wasn't
witness?
given the time because, Judge, when I got to that point where I was going through individual accounts and starting to do that, I was cut off immediately. Immediately, I was stopped. And I was prevented from doing that. But those records are there, and those records, when you look at them, show that the time entries are not accurate. So, for example, he changed his time entries, and we point this out to you. He took entries that were clearly only about 60B in res judicata, and then he modified them later to try to make them into something different. And we pointed that out, and that's all in the record.
Do you even need then to cross-examine him on those?
Yes.
Or is it enough that you submitted the post-hearing brief?
No, I believe that I needed to cross-examine him on all of these, and I was prevented from doing that.
So just, if you have evidence in these time records that he's charged unreasonable time, time that doesn't pertain to the issue, block billed time, whatever, like, the normal way that fee applications are challenged is showing all that to the court in some sort of written filing that makes that argument. Like, what beyond that do you need to question him about?
Because because what he did was he took his time that were originally was block billed and had all sorts of entries for things that were not properly recordable. And then he modified that bill and he rewrote the time. And that's what I was cross-examining on was the rewriting of his time and changing it. So he would take associate time that he billed for. There was one entry, it was all associate time. And then he made it all his time. And so now I want to question him, why did you decide to change this from associate time on these matters, change the description, and make it your time? So and there was a lot of this.
Did you get to question him on that?
No, I didn't, because I was prevented to, but that's what happened. You can see that in the records, because when you take a look at the filed records and you see the original affidavit with his chime charges that have the associate time, and then you see the subsequent one where he changes that very date and that very entry, and he makes that change, and I pointed this out in my briefing. Then, of course, it's there, but I want to know, okay, now did you make a mistake and you knew this, and you changed it, and you realized, oh, that isn't associate time, that's my time, with a completely different hourly rate. Why did he do this thing with the hourly rate? Because a lot of what he did with this contingency fee, the last time we were on appeal, he then created a contingency fee agreement. Why did he do that? He did that because he only had one fee arrangement with her, and it was from 2009. It was for $350 an hour. He had the right to bill her every month. He didn't do that.
You are over your time.
And I know that you keep my time and you will instruct me on that. And I think that my brief carefully answers your questions already. Thank you so much.
Thank you. Thank you both for your arguments today. The case is now submitted, and we will issue a timely decision. Have a good rest of your morning.